Immigrants, here's some really important information for you. Do you know that now, if you don't look or sound American enough, ICE can briefly detain you for questioning? Immigration officers only need what the law calls reasonable suspicion that you are unlawfully present in the US. After the Supreme Court's September 8th ruling in a case called Noem versus Pedro Perdomo, that can mean your race or your skin color, your accents, the kind of low-paying job you have, or even where you wait for a ride. Here's what happened. The federal judge in Los Angeles, Mami Ewusi Mensah Frimpong, she had blocked ICE from using those four factors. The government asked the Supreme Court to lift that block. In a 6-3 decision, the Supreme Court sided with the Trump administration and granted a stay. Justice Kavanaugh cited immigration law that allows immigration officers to briefly detain anyone they believe may be an immigrant on reasonable suspicion and question them about their right to remain in the United States. The Supreme Court itself stated in another recent case decided in 2025, Trump versus Wilcox, that stays are not final rulings. It also said they are interim orders, but interim orders can guide how courts act in similar cases. That's the danger here. This ruling in Noem versus Pedro Perdomo was only a stay. It was not a binding merits decision. It's not a presidential decision because it was not a full merits hearing, but in practice, it gives ICE the green light, and it's unlikely to stay limited to Los Angeles. ICE officers across the country will likely treat it as permission to use these factors until another court says so. And lower courts may also defer to the Supreme Court signal, or they are likely to follow the Supreme Court's lead. So if speaking English with an accent or your skin color can now make you a target, what does safety in public even look like for immigrant communities in the United States today?